Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Welcome to the deep dive. Today, we're really getting into a legal case that honestly changes quite a bit about how we think about software patents in India. If you've ever wondered about that line between innovation and IP, especially with tech moving so fast, well, this deep dive is definitely for you. We're going to unpack a recent Delhi High Court judgment. It's got pretty big implications for computer-related inventions.
Yeah, absolutely.
Our goal here is to slice through the legalese and pull out the key stuff, what happened, why it happened, and what it means going forward.
And what's really fascinating about this Kroll Information Assurance versus the Controller General case is how it gives us such a clear view on the evolving patent law landscape in India, especially around this idea of technical effect for software. It's been a bit fuzzy.
Right.
This case really shows the courts trying to get to grips with, well, new technology.
Okay, let's unpack this then. Maybe start with the basics, just set the scene for us.
Absolutely. So this was an appeal. The case number, if you need it, is CA KEBM.IPD-PAT 4392022. It was heard in the High Court of Delhi, right there in New Delhi.
Okay.
And the judgment itself is very recent, July 1st, 2025. They'd reserved it back on April 30th.
Got it. And who were the main parties involved here?
Well, on one side, the appellant was Kroll Information Assurance, LLC. They're U.S.-based. They weren't the original applicant, though. It was a company called Taversa, INC. Kroll acquired the application later.
Oh, okay.
And on the other side, the respondents were basically the Indian Patent Office, the Controller General of Patents, Designs, and Trademarks, and also the Assistant Controller who made that first refusal decision.
Right. The ones defending the original decision, and the lawyers arguing the case.
For Kroll, you had Mr. Vineet Rohilla, Mr. Rohit Rangi, Mr. Tanvir Malhotra, and Mr. Debashish Banerjee. And representing the Controller General were Mr. Piyush Berwal, Mr. Nikhil Kumar Chaubey, Mrs. Jyotsna Vyas, and also Mr. Praveen Kumar, an officer from the Patent Office.
So quite the legal teams on both sides. And who was the judge overseeing this appeal, the one making the final call?
That was Honorable Mr. Justice Amit Bansal. And it was just him, a sole judge, delivering a unified decision. No split opinions or anything like that.
Okay, interesting. Now, you mentioned this wasn't exactly a quick process. This patent application has a history going way back, right, to 2005.
Indeed it does. A long journey. It starts April 12, 2005. That's the priority date, claimed from an earlier U.S. patent application.
Okay.
Then an international application under the PCT, the Patent Cooperation Treaty, was filed in April 2006. And that led to the Indian application, number 8100 DLLNP 2007, being filed as the national phase entry in October 2007.
So when did the Indian Patent Office actually start looking at it, the examination process?
Well, the request for examination was filed pretty quickly, November 2007. The application got published in July 2008. But the first examination report, the FER, where they raised the first set of objections, that didn't come out until February 19, 2013.
Wow, 2013. That's quite a gap between filing and the first real feedback.
It is a significant delay.
So what kind of objections were raised back then in that first report?
They were substantive ones. Things like lack of invention, lack of inventive step, basically saying it wasn't new or non-obvious enough. Also, that the claims weren't defined clearly enough, maybe contrary to public order, and importantly, that it related to an algorithm or computer program per se. That Section 3K issue came up early.
Right, that key exclusion. And Kroll responded.
Yes, they responded in October 2013, and they proposed some amendments to their claims trying to address those points.
Okay, so fast forward from 2013, what led to the appeal eventually?
Right, jump ahead quite a bit to April 2019, another hearing notice goes out.
Yeah.
And again, similar objections. Lack of invention, the amendments weren't allowable, and still this issue of it being an algorithm or computer program per se.
So the core issues persisted.
They did. The hearing happened May 13th, 2019. Kroll filed some more arguments after the hearing on May 27th. And then finally, June 25, 2019, the Assistant Controller issued the impugned order, That's the decision Kroll appealed, refusing the patent application.
And that refusal, that impugned order, it was based on specific grounds. You mentioned 3.
Exactly. 3 main reasons given in the refusal. First, the controller said the proposed amendments Kroll made went beyond the scope of the original invention, which is not allowed under Section 59 of the Act.
Okay.
Second, lack of inventive step under Section 2.1, particularly considering some prior art labeled D1. They said it was obvious.
And the third?
And third, the big one, the subject matter related to an algorithm or computer program per se, falling under Section 3K. That exclusion was key. So based on those grounds, Kroll filed their appeal in 2022.
Okay, this is where it gets really interesting. Let's talk about the invention itself. What exactly was Kroll trying to patent here?
Right. The title was quite broad. A system, method, and apparatus to locate at least one type of person via a peer-to-peer network. Essentially, it described a system to find specific types of people, or maybe specific types of information, on a peer-to-peer network.
How would it do that?
By using specific search terms for profiling. The example given was locating military personnel by searching for a term like FRAGO. That's a military operations order fragment on a P2P network.
So like a targeted search on networks where people share files directly?
Exactly. Peer-to-peer, like, think BitTorrent or similar systems where users connect directly, not through a central server. It aimed to sniff out specific data or users in that environment.
Okay, interesting tech. So given that invention, what were the absolute core legal questions the High Court had to decide on?
The High Court really zeroed in on 3 key legal issues stemming from that controller's refusal.
Yeah.
First, were Kroll's amendments to the patent claims okay under Section 59? The controller said no, they went too far.
Yeah.
Second, and this was arguably the main event, did the invention fall foul of Section 3K? Was it just an algorithm or a computer program per se?
The big software question.
Precisely. And third, did it lack an inventive step under Section 2.1? Was it obvious, especially when looking at that prior art, D1?
Okay, so those were the battlegrounds. How did Kroll argue their case? What were their main points against the refusal?
Well, on the amendments point, Section 59, Kroll argued the controller got it wrong. They said their changes actually narrowed the claims, made them more specific, which is generally allowed, and that these features were fully described in the original specification anyway.
So they were just clarifying, not adding new stuff.
That was their argument, yes. More clarification than new invention.
And on the crucial Section 3K point, the computer program exclusion.
There, Kroll strongly contended their invention was more than just software code or an algorithm. They highlighted its function, identifying sensitive info and users on these P2P networks. They argued this addressed a real technical challenge, like stopping accidental data leaks.
So they claimed a technical effect.
Exactly. They said it achieved a technical effect by making the P2P environment more secure. They felt the controller ignored the hardware aspect, how the software interacted with the network and machines. They even pointed to another case, Lava International, to support this view.
Okay. And what about the inventive step argument? The claim that it was obvious?
Kroll pushed back there too. They said the prior art, D1, was different because it dealt with a client-server network, not their peer-to-peer system. Fundamentally different architecture. And they also made a point of saying, look, similar applications for this same invention got granted patents in the US, China, Australia, Japan, suggesting other major patent offices saw it as inventive.
Right, pointing to international acceptance. So that was Kroll's side. How did the controller respond? What were their counter-arguments?
Well, the controller stuck to their guns. On Section 59, the amendments, they maintained the changes weren't supported by the original claims. They saw it as adding new matter. On Section 3K, the core issue, they doubled down. They argued the invention was essentially just a computer-implemented algorithm for processing search queries. They stated it didn't solve any real technical problem, nor did it demonstrate a genuine technical effect on the hardware itself, thus excluded under 3K.
So no tangible technical improvement in their view.
Exactly.
Yeah.
And regarding inventive step,
Yeah.
the controller argued Kroll hadn't actually shown how their invention was better than prior art D1. No evidence, no comparative analysis was provided, they claimed. They basically said searching on a P2P network is pretty routine, kind of obvious, so the invention lacked that necessary inventive spark under the law.
Okay, so arguments heard from both sides. What did the High Court decide in the end? And what was the logic?
The bottom line, the High Court upheld the controller's refusal. The appeal was dismissed. Kroll didn't get the patent.
Ah, so the refusal stands. But you mentioned earlier the court disagreed on something.
That's the interesting twist. Yes, on that first point, the amendments under Section 59, the High Court, actually disagreed with the controller.
Really?
Yes, they set aside that part of the controller's finding. The court looked at Kroll's proposed changes, features 3 and 4, in Claim 1 specifically, and said, actually, these do seem to limit and narrow the scope of the original claims. They considered them explanatory, fully disclosed in the original spec, and therefore permissible under Section 59. They cited another case, Nippon A&L, to support this reasoning.
So a partial victory for Kroll on the procedure, but it didn't change the final outcome.
Exactly. A win on process, but not on substance.
So what was the decisive ground then? Why was the refusal ultimately upheld?
It all came down to Section 3K, the exclusion for computer program per se or algorithm.
Yeah.
That was the killer blow. The court found that Kroll's invention, at its heart, just enabled a search on a P2P network using, essentially, standard computer hardware. Nothing special required on the hardware front. They described the search function as conventional computer program behavior. And crucially, they said it didn't actually enhance the functionality of the hardware itself.
So that technical effect Kroll argued for. The court just didn't see it.
Precisely. The court was very explicit. They said the profiling aspect of the invention is abstract in nature and lacks any technical character. They pointed back to the official guidelines, the CRI guidelines, and other key cases like Lava International, Microsoft, BlackBerry,
Right.
and reiterated the principle. For software to be patentable, it needs to show a significant technical effect or advancement of the hardware, or maybe a technical transformation that significantly enhances the hardware functionality.
Something tangible.
Yes, something more than just clever instructions running on a generic box. Kroll's invention didn't meet that bar in the court's view. It was seen as abstract software behavior.
And what about the inventive step argument? Did the court even weigh in on whether it was obvious or not?
Nope. Since they firmly decided it failed under Section 3K, they stated they didn't need to go into the inventive step question under Section 2.1. The Section 3K finding was enough on its own to justify the refusal.
Okay, so that clarifies the court's reasoning. This brings up the bigger picture. What's the impact of this judgment? Does it set a strong precedent?
Oh, absolutely. It holds significant legal weight. Being a judgment from the High Court of Delhi, specifically Justice Amit Bansal, it's a binding precedent. That means all the lower courts and tribunals, including the Patent Office itself, within that court's jurisdiction, have to follow it.
So future patent examiners have to take this ruling into account.
Yes. When they look at similar applications, they'll be expected to apply the principles laid out in this Kroll decision. It really helps clarify the rules of the game.
And the main rule it clarifies is?
It's the interpretation of Section 3K. This judgment powerfully reaffirms how that exclusion for algorithms and computer programs per se works in practice. It hammers home the point. Just having an algorithm, even if it's part of a system, isn't enough. You must demonstrate that significant technical effect or advancement of the hardware.
It raises the bar, perhaps, on proving that technical contribution.
It certainly reinforces it. And it also gives some guidance on amendments, even though Kroll lost overall.
That's true. The court overturned the controller on Section 59.
Exactly. So that part of the judgment reinforces that applicants can amend their claims, provided those amendments clarify or narrow the scope and don't sneak in totally new ideas. That's valuable procedural guidance for anyone navigating the patent system.
Okay, so let's distill this down. For you, our listener, maybe you're an innovator, a developer, someone involved in tech IP. What are the absolute key takeaways from this deep dive into the Kroll case?
I think the number one takeaway, the most critical point is this. For any computer-related invention, a CRI, to get a patent in India, it has to show a clear, significant technical effect or technical advancement of the hardware. It can't just be an algorithm or a computer program per se operating in the abstract.
So simply putting clever software onto generic hardware isn't going to cut it anymore. You need to show the software fundamentally improves or changes the hardware itself.
That's the essence of it. The court was quite blunt. An invention that's just a mere sequence of instructions stored in hardware without solving any technical problem or offering any technical advancement to the hardware, that's going to fall under Section 3K.
And Kroll's invention, even with its specific goal, was gamed.
Conventional computer program behavior. The profiling part was seen as abstract, lacking that necessary technical character. So this judgment really reinforces a consistent line from Indian courts. Abstract software, pure algorithms, without that tangible link, that technical contribution to the hardware, they just aren't patentable subject matter in India.
Wow. That was a really, really insightful deep dive. It definitely clarifies the landscape for software patents in India, but also highlights just how tricky defining innovation is in this digital age.
It really does. It shows this constant effort, balancing the need to encourage real technological progress with the need to avoid letting people monopolize abstract ideas or basic computing functions. It's a fine line.
A very fine line. And it leaves us thinking, doesn't it? This whole question of what truly counts as a technical effect for software, that's not going away. It's going to keep driving discussions and shaping how innovation unfolds. We hope this deep dive helped you understand the complexities and why these judgments matter so much.